that the two files will henceforth go hand in hand, while the proceedings file of MN 06-2025 will be used to conduct the matter. The applicants in the motion on notice are the same applicants in the ex parte motion, while the respondents to the motion are the same persons described as previous to the judgment debtors. The relief sought in the motion on notice by the applicants are as follows. I have verbatim copied the exact relief sought by the applicants. There are 4 reliefs. I have also summarized the facts in support of the motion, as well as the written address in support. And I have gone further to summarize the respondents' response to the motion, as well as their written address. I'll go straight to the decision.
As purposes.
This court, Quorum Honorable Justice O.O. Oyewumi, now JCA, delivered judgment in suit number NICN ABJ 263-2023 on 11th March 2024. A copy of the judgment is Exhibit N8 of this application. The claimants in this suit were 14 in number. The names have been reeled out here. I don't need to repeat them. The defendants in the suit were also listed. I have also listed the defendants, and their names are captioned. The first to 13th claimants and the defendants were members of the 14th claimant union. The names sought by the claims sought by the claimants in the suit were as follows. I have captured the claims sought in the suit. That is to say ABJ 263-2023. I have reeled out the relief sought in that suit. There are 10 reliefs. And in the judgment in that suit, these orders were made at page 50 to 60 of Exhibit N8. 1. The claimant's action succeeds in the most part, except relief 1 in the originating summons, while reliefs 2, 3, 4, 5, 6, 7, 8, and 10 succeed. 2. Relief 9 succeeds only to the extent that the first defendant, as the chairman of the Board of Trustees, has no right to interfere in the day-to-day running of the affairs of the union, as the role of the Board of Trustees is only limited to mediatory and advisory role, and does not include interfering in the running of the activities of the union. 3. The first defendant, Alhaji Najim Usman Yasin, is hereby restrained from interfering in the affairs of the union. 4. The actions of the defendants, which have been earlier held in this judgment to be contrary to provisions of the Constitution of the Union, and all actions taken by the 4th defendant, Kayode Agbeyangi, as acting General Secretary, are hereby declared unlawful, null, void, and of no effect whatsoever. 5. The first to 7 defendants and their previous are restrained from interfering in the affairs of the 14th claimant. 6. This judgment is to be complied with forthwith, and 7 parties are to bear their costs. Now, the defendants in the suits appealed the judgment to the Court of Appeal, and judgment was delivered in the appeal on 8 November 2024. The Court of Appeal dismissed the appeal and affirmed the judgment in suit ABJ 263. A copy of the judgment is Exhibit N9. The applicants who claim to be previous to the judgment creditors now seek to enforce the judgment against the respondents, who the applicants allege to be the previous to the judgment debtors. Both the applicants and the respondents in this application were not named parties in the suit. However, they are all members of the Niger State chapter of the 14th claimant judgment creditor, which is the NURTW. The applicants base their contention that they are the previous to the judgment creditors, while the respondents are the previous of the judgment debtors, on Exhibits N1 and N3. According to the applicants, Exhibit N1 was signed by the 4th judgment debtor on behalf of the judgment debtors, while Exhibit N3 was signed by the 6th judgment creditor on behalf of the judgment creditors. This is what the applicants want the court to use to conclude that the respondents are previous of the judgment debtors. I have examined exhibits N1 and N3. The contents of the documents did not make the applicants privy to the judgment creditors, nor the respondents privy of the judgment debtors. The first to 13 judgment creditors are members of the NURTW, while the judgment debtors are also members of the same union. The individuals who are members of the union are deemed to be privy of the union that brought them together. Members cannot derive privities from fellow members just because the union has been factionalized. In as far as the factions remain in the same union, all of them are privy of the union to which they are members. More so, the dispute in suit NICN ABJ 263/2023 relates to members' dispute on infractions of the union constitution regarding election into offices in the union. All the parties to the dispute are privy of the union. The fact that some members were the defendants in the suit did not make them non-members of the union. Accordingly, both the applicants and the respondents in this application, being members of the union, are privy of the same union. The mere fact that the respondents are alleged to have been elected into office in the election conducted. I'm sorry. Can you move this? I don't know. Or I should just leave it there because I can't move it. It's okay. The mere fact that the respondents are alleged to have been elected into office in the election conducted by the parties against whom the judgment was given does not make the respondents privy of those members. Accordingly, I hold that the applicant's assertion that the respondents are privy of the judgment debtors does not hold water. I have seen that the reason the applicants sought to enforce the judgment against the respondents is their belief that the respondents are privy to the judgment debtors. This reason, which is not cogent, is itself not enough to make the respondents liable for enforcement of the judgment against them. The respondents were not named defendants in the suit, and I did not see any relief which was granted or directed at the respondents or to their offices in the Niger State Executive Council of the NURTW. I have also considered the provisions of Order 2, Rule 16 of the Judgment Enforcement Rules relied upon by the applicants for seeking to enforce the judgment against the respondents. The applicants were not parties to the suit and accordingly did not obtain any order in their favor in the suit. Rather, it is the NURTW and the National Administrative Council who obtained the orders in the suit. If the judgment is to be enforced against any member of the union, it is the judgment creditors who should take that step. In my view, Order 2, Rule 16 of the Judgment Enforcement Rules does not entitle the applicants to enforce the judgment in ABJ 263/2023 against the respondents. In any event, I do not think the complaint of the applicants in this application is one that can be brought or addressed by way of enforcement of the judgment in suit ABJ 263. The respondents were elected into office as Niger State Executive Council in an election or selection, as the applicants call it. The applicants are attempting to say the election is invalid by reason that it was conducted by the judgment debtors in violation of the judgment. I have seen from the depositions that the election of the respondents was conducted before the judgment in suit ABJ 263/2023. Whether the respondents' election is valid or not is a substantive matter, and any challenge to their election is a fresh course of action. The judgment in suit NICN ABJ 263 cannot be used to remove the respondents from office in the absence of a proper suit to determine the validity of their election into office. At best, the applicants can rely on the judgment to found a suit against the respondents, but to seek to remove them from office in the guise of enforcing a judgment against the respondents will not suffice. I have carefully considered the applicant's application, but I find no merit in it. The motion is dismissed. There being nothing left to determine in this suit, it is accordingly dismissed. This order of dismissal relates to both NIC and ABJ 06/2025 and NICM MN 10 2025. Parties shall bear their respective costs. This is the decision of the court, and it is entered accordingly.
As
As
God
God
pleases.
pleases.
We are most grateful, Your Lordship. We thank the
Thank
court
you.
for the
So you got the message. You can get a copy of your judgment of the judgment or ruling later today. If are you in Mina?
I'm in Mina, my Lord.
Okay.
Yes,
Okay. So
I'm
I'll get them signed. Hopefully by tomorrow you should be able to lay hands on a copy. But
As God
I
pleases.
think I have pointed you to the right direction, which is
As God pleases. We are very grateful, sir.
to the effect that a new course of action has arisen. Okay.
As God pleases, yes. We thank my Lord
Thank
for the
you.
industry.
You're
Thank you,
welcome.
my Lord.
Thank you. Thank you. I'm sorry to have delayed the reading of this ruling up to this time. The court has been inundated with millions of judgments. I mean, we're delivering judgments running close to 40 within this quarter alone. And we don't want to kill ourselves, so we needed to take it easy.
No, we don't want that also. We thank my Lord. You understand? Thank you very much.
Thank you. Especially you Mina people, you have a way of pushing us to the wall. But
it's not all of us, my Lord. It's not all of us. Thank you, my Lord. My grateful.
Well
thank
done.
you.
Thank you. All right.
All right.
Okay.
Thank you. All right. Okay.
All right.
Have
Thank
a great
you.
day. Thank you, man.
Okay.
Yes.
You too. Mohammed, call the next case.
Yes, Lord. Case number NSN/ABJ/357/2024 between Incorporated Trustee of Association of Laboratory Science of Nigeria, Dr. Uche Odeyema, and Professor James Garba Deme and others. Lord, parties absent.
Appearances. Did you communicate with the lawyers?
Yes, Lord. Barrister Obaga, the claimant lawyer, said that he's writing an exam, my Lord, but my Lord can deliver the ruling.
What about the defendants? Yes,
it's online. It's online, my Lord.
Okay, can you please announce your appearance, Mr. Barikua?
Respectfully, my Lord. BK,
yes.
Barikua.
Yes. Yes.
My humble appeal is for the first and second defendant.
Okay.
My Lord, I apologize for the absence of the defendant.
No problem.
Yes, my Lord. My Lord, the case is...
You don't need to announce. Didn't I send for you?
Not convenient. Yes, my Lord.
Accelerated. Okay, so the ruling of the court. On 3rd March 2026, I had 5 different applications filed by the parties. The applications in the order they were taken are...
Yes, madam.
The applications in the order they were taken are: 1, claimant's motion for extension of time. Filed on 21st February 2025. 2, preliminary objection filed by the first and second defendants on 4th March 2025, seeking the court to decline jurisdiction to hear the suit. 3, motion filed by the first and second defendants on 24th February 2025, seeking the striking out of the name of the first claimant from the suit. 4, Motion for the committal of the second defendant for contempt filed by the claimant on 2nd December 2024. And 5, motion for interlocutory injunction filed by the claimants on 7th February 2025. I will now rule on the applications.
Thank you,
The first one is the claimant's motion filed on 21st February 2025. In the motion, the claimant sought an order extending time for them to file and serve their further and better affidavits and reply on points of law, and to deem the further and better affidavits and reply as properly filed and served. The motion was supported with the affidavit deposed to by the second claimant and a written address. The first and second defendants opposed the motion by a counter affidavit and written address filed on 3rd March 2025. I have read the affidavit and the written address in support of the motion. I have also read the counter affidavit and written address in opposition. On 7th February 2025, the claimant had filed a further affidavit in support of their motion of 2nd December 2024. And on 21st February 2025, the claimants filed a reply on points of law to the preliminary objection of the first and second defendants. The claimants were out of time to file these processes and have brought this instant motion for extension of time. I have seen the reason of ill health of the counsel for the claimants given for the delay in filing the processes. I have also seen that the claimants have paid the fees for the period in default. The claimants' further and better affidavit and reply on points of law are in respect of the applications already heard by this court and to be decided today. This court has the discretion in Order 57 Rule 4 of the Rules of Court to extend time for any party to do any act or take any step required in the rules. The interest of fair hearing requires that the claimant's said processes be allowed in and be used in the determination of the applications. Accordingly, I will exercise my discretion in favor of the claimants and allow the application. The motion is granted. Time is extended for the claimants to file and serve their further and better affidavits and reply on points of law. The further and better affidavits and reply on points of law which have already been filed and served are deemed as properly filed and served. The second application. There's the first and second defendants' motions of 4th March 2025 and 24th February 2025. The first and second defendants filed 2 motions. The first motion was filed on 4th March, while the second motion was filed on 24th February 2025. In the first motion, the first and second defendants sought an order striking out the name of the first claimant from the suit filed by the second claimant and his counsel, I.O. Ogbaga Esquire. The grounds of the motion are that the suit was not approved by the first claimant and the National Executive Council of the Association of Medical Lab Scientists of Nigeria. There are 6 grounds. I don't think I need to reel them. They are contained in the body of the ruling. In the second motion, the first and second defendants sought an order declining jurisdiction to hear and determine the suit, and the grounds of the motion are as follows. Again, there are 5 grounds. Now, both motions were supported with affidavits and written addresses. The affidavits were deposed to by the second defendant. In response to the first motion, the claimant filed a counter affidavit and written address on 5th December 2025, while the first and second defendants filed a further affidavit on affidavit of the second defendant on 15th December 2025. With respect to the second motion, the claimant filed a reply on points of law on 21st February 2025. From the above grounds of the 2 motions, the facts deposed to in the affidavits and in the written addresses in support, it is clear to me that the motions are similar in terms of issues to be determined in the motions. Although different reliefs were sought in the motions, the same issues will eventually arise for determination in both motions. For this reason, I will consider them together. Going by the grounds of the motions, I have identified 4 issues which I will determine with respect to the 2 motions filed by the first and second defendants. The issues are 1, whether the court has jurisdiction to entertain the suit. 2, whether this court is functus officio in respect of this suit in view of the earlier judgments in ABJ 368 and ABJ 348. 3, whether the approvals of the first claimant and that of the National Executive Council of the Association of Medical Lab Scientists of Nigeria must be sought and obtained to institute this suit on behalf of the association. And 4, whether the second claimant can maintain this suit against the defendant. Now, the resolution of the issues are what follows. Issue 1, it was contended by the first and second defendants in the motion of 4th March 2025 that this suit is not an employer and employee dispute, neither is it a labor, industrial, or trade union dispute. It was also averred that AMLSN is registered under Part F of CAMA, and it is not a trade union. For this reason, it was contended that it is the Federal High Court that has the jurisdiction over this matter and not this court. I have summarized the content of the written address in support of the motion copiously. And I have also read the claimant's reply on points of law to the motion, where the Learned Counsel did not address the court on the submissions made by counsel for the first and second defendants on the issue of the court with jurisdiction to entertain the suit. Be that as it may, the issue of jurisdiction raised by the first and second defendants is an issue of law to be determined from the applicable constitutional provisions vis-a-vis the subject matter of the suit as disclosed in the originating processes. It is not in dispute that the AMLSN is an association registered under Part F of CAMA. It is also not in dispute that as an association, it has its constitution, which is annexed to the motion of 4th March as Exhibit A7. The complaint of the claimant in this suit concerns the office of National President of the association as provided in the association's constitution, particularly that some provisions of the constitution have not been complied with in respect of the performance of the functions of the National President, and in compliance with the judgment of this court in suit ABJ 368, delivered on 10th October 2023. The claimant sought reliefs which required this court to consider the judgment and some provisions of the constitution of the association and make some declarations based on the said judgment and provisions of the constitution. The subject matters which this court can entertain as provided in section 254C1 of the constitution include those provided in subsection 1J. This court has jurisdiction to determine any question as to the interpretation and application of any judgment of this court and the constitution of an association of employers or any association relating to employment. See section 254C1J3 and 5. In view of these provisions, this court has jurisdiction to entertain the suit. Resolution of issue 2. Ground 8 of the motion of the first and second defendants, filed on 24th February, is that this court became functus officio on 10/10/2023 and 13/6/2024, in respect of the prayers sought in suit 368 and 348, which are exactly the same with this suit. See paragraph 17 of the affidavit in support of the motion, where the content of ground 8 was repeated. In paragraph 6E of the affidavit in support of the motion of 4th March, the second defendant deposed that the issues for determinations in this suit are the same with the issues canvassed in suit ABJ 348 and 368, earlier decided by this court, with the same parties, and all the reliefs asked for were decided by this court on 10/10/2023 and 13/6/2024, respectively. I have rehashed the content of the written address in support of the motion as presented by Learned Counsel for the first and second defendants, where he posed the question whether the court is not functus officio. In response to this ground of the motion, it was averred in the counter affidavit of the second claimant that this suit is different from ABJ 368 and 348. As the parties are different, the reliefs or claims are different, and the facts of the cases are different. And that this suit is seeking the interpretation of this court to determine whether, in view of the judgment of this court of 10 October 2023 and compliance thereto on 25th June 2024, the actions taken by the defendants are legal. According to counsel, when suits ABJ 68, is it 348 or 368? ABJ 368, right? Yes, 2020,
Yes,
and ABJ 348 2023 were filed. At the time they were filed, the second claimant had not been sworn in as the national president of AMLSN. The submission of learned counsel for the claimants in his written address has also been summarized, as well as the contention of the first and second defendants based on the ground of their motion. I will proceed from there to read that it is settled law that after delivering judgment in a matter, the court becomes functus officio with respect to the issues resolved and determined in that judgment. The court cannot revisit the issues by giving a second judgment or to allow parties reopen and relitigate the same issue again. I refer to the case of Babington Ashare versus EMA General Enterprises, 2012, and Bulus versus Okpala, where it was held that the law is that no court or judge has the power of rehearing, reviewing, or varying any judgment or order, either in an application made in the original action or in a fresh action brought for that purpose, and as that task is for the appellate courts. On the other hand, abuse of court process will occur where a party seeks to relitigate an issue which has been previously decided between the same parties in a previous suit. See Niger Gate Limited versus Niger State Government, 2008, Akukuje versus Akwido, 2001, Adone versus Ikebudu, 2001. Now, in an application where the issue that the court is functus officio or a suit constitutes abuse of court process is raised to challenge the competence of a suit, the court is to examine the judgment in the previous suit to know what the subject matter, issue, and parties of the suit were, and then compare with the subject matter, issue, and parties in the current suit, as disclosed in the originating process, to be able to determine whether or not it has become functus officio in respect of the current suit, or whether the current suit constitutes an abuse of court process or not. In an application of this nature, the party who asserts that a suit is an abuse of court process must produce the judgments through decisions in the previous suit relied upon to the court by exhibiting them to the application, if they are not already before the court in the suit. In this case, the first and second defendants exhibited the judgment in suit NIC ABJ 348/2023 to their motion of 4th March of 2025, which they marked exhibit A5. However, they did not exhibit the judgment in ABJ 368/2022, either of the motions. I have, however, seen that the claimants front-loaded the judgment in suit ABJ 368/2020 with the complaint. Since the judgments in both ABJ 368 and 348/2023 are before me, I will examine them to determine the assertions of the first and second defendants. In suit 368, the defendants include first claimants, first and second defendants in this suit who were the first, second, and fifth defendants. However, the facts of that suit, the issues and the relief sought therein are different from those of this suit. In fact, the orders made in the judgment in suit ABJ 368/2020 are the foundation of the claims sought by the claimants in this suit. In my view, suit ABJ 368/2020 is different from this suit, and issues and claims in this suit have not been decided in suit 368. After the judgment in 368, the second claimant filed suit 348/2023 on 30th November 2023. I've examined the judgment delivered on 13 June 2024 in ABJ 348, which is exhibit A5 of the motion of 4th March 2025. And the statement of facts of this suit I observed that the first claimant in this suit was the fifth defendant in 348, while the first, second, third, fourth, and fifth defendants in this suit were the first, second, 14th, 15th, and 16th defendants in suit 348. Without a doubt, the parties in ABJ 348 and in this suit are the same. From the claims sought in suit ABJ 348 and the claims sought by the second claimant in this suit, I have seen that reliefs 2, 3, 4, 5, 6, 7, 9, and 10 sought in suit 348 are the same as reliefs 1, 2, 3, 4, 5, 6, 7, and 8 sought by the second claimant in this suit. However, the facts of the two cases on the basis of which the reliefs were sought are different. I have also seen that my decision in 348 will not apply to this suit in view of the mode of commencement of this suit and the facts of the suit. I hold that I am not functus officio in respect of this suit, neither is this suit an abuse of court process. Resolution of issue 3. The contention of the first and second defendants on this issue is that the suit is premature because the suit was commenced on behalf of the association without the approval of the National Executive Council, and no resolution was made by the incorporated trustees of the association, which is the first claimant, authorizing the filing of this suit. Counsel for the first and second defendants referred to Article 9b(4) of the Constitution of the association and submitted that the provision is a precondition for the institution of cases in court. It was argued that the National Executive Council of the association is to approve all legal proceedings and recommend same to the Board of Trustees. Council concluded that since the requisite approval was not obtained in respect of this suit should either this court should either strike out the first claimant from the suit or strike out the suit for being premature. In the claimant's counter affidavit to the motion of 24th February, the second claimant said he was informed by Chief Mrs. Aduni Udu, the chairman of the first claimant, that the letters written to the president of this court by two members of the first claimant, including Exhibit A3, do not represent the position of the first claimant. He also said the BOT of the first claimant authorized the appointment of I.O. Ogbaga as the legal advisor of AMLSN, and he was briefed to file this suit. In the written address in support of the counter affidavit, learned counsel for the claimants submitted that Article 9b(4) of the AMLSN Constitution requires that NEC approves legal proceedings necessary to give effect to any resolution of NEC. Such approval is not in effect an approval per se, but an approval to recommend that the BOT or the incorporated trustees take a legal action. The intention of the article is that the decision of NEC can be recommended to the BOT and not that the BOT should seek approval from NEC before taking up any legal action or proceedings on behalf of the association. Council also referred to the provisions of Article 19C(6) of the AMLSN Constitution, which provides that the BOT shall entertain, approve, and institute litigation on behalf of the association to submit that any decision or resolution of NEC, especially as it relates to litigation for the AMLSN, is subject to approval from both. Council cited Section 830 of CAMA 2020, and I will skip further submissions because they are already embodied in the ruling. I have seen the one of the powers of the NEC is in as Article 9b(4) is to approve all legal proceedings which may be necessary on behalf of the association and recommend same to the BOT to protect the interests of the association as a whole. I have again seen Article 19C(7) of the AMLSN Constitution, which provides the function of the BOT to include the functions of the BOT to include shall entertain, approve, and institute litigation on behalf of the association. By these provisions, the NEC of the association is conferred with power to approve all legal proceedings of the association and recommend the approval to the BOT. Then the BOT approves and institutes the action on behalf of the association. From the provisions, the approval of both the NEC and BOT is required for any suit instituted on behalf of the association. The question at this point is whether the approval of both the NEC and BOT were obtained before this suit was filed on behalf of the association as first claimants. When the defendants asserted that no such approval was obtained, the burden shifted to the claimants to show that the requisite approvals were obtained before this suit was instituted. In the counter affidavit of the claimants, it was averred that the BOT of the association authorized the appointment of Ogbaga as a legal advisor, and he was also briefed to file this suit. I've exhibited by the claim 006 and 007, referred to in paragraphs 3P and Q of the claimant's counter affidavit, are not readable. The remaining exhibited documents do not contain approval for the institution of this suit on behalf of the association. I cannot find any minutes of meeting or the resolution by the NEC approving this suit and making recommendation to the BOT. I cannot also find any minutes of meeting or the resolution by BOT approving that this suit be instituted on its behalf. The claimants are unable to show that the approval of both NEC and BOT were obtained before this suit was filed on behalf of the association. The implication is that the approvals of the NEC and BOT in Article 9B4 and 9C7 of the Constitution before a suit can you get me water? Before a suit can be instituted on behalf of the association, were not obtained or given. Thank you. Without the requisite approval, the first claimant cannot be added as a claimant to this suit. Consequently, this suit not having been competently done for the first claimant cannot remain a claimant in the suit. It is hereby struck out from the suit.
As you call, please.
Now, resolution of issue 4. Resolution of issue 4. I have expanded the content of the motion of 4th March 2025, where the first and second defendant contended that the second claimant is not a financial member. Thank you. Excuse me, please. Not a financial member of AMLSN. And that assertion was reasserted in paragraph 6L and M of the affidavit in support of the motion. The second defendant who deposed to the affidavit relied on the financial records and dues payment of the members of the association, which he said was exhibited as A8. I have expanded the content of the written address in support. It's contained in the body of the ruling. In the second claimant's reply on points of law, it was argued that there is no provision of the Constitution of AMLSN and there is nowhere in the operational guideline that provides that a member shall cease to be a member if he is not financially up to date. This is in addition to the fact that this court had earlier ruled that the operational guideline of AMLSN is not a document with any probative value. Again, there's no paragraph of the affidavit in support of the application that the second claimant not being a financial member, as the issue was only raised and argued by the first and second defendants in their written address. The document, which is said to be list of people in good standing and referred to as Exhibit C in the address of the first and second defendants, does not exist in their affidavit. Upon considering the averments and submissions made by the first and second defendants, it is observed that the whole basis for contending that the second claimant is not a financial member is that he is not qualified to hold any national responsibility in the association. In other words, what the first and second defendants have told this court is to be the effect I've told this court to be the effect of not being a financial member of AMLSN is that the person cannot hold any national responsibility in the association. Accordingly, it is not the contention of the first and second defendants that the second claimant cannot institute and maintain an action against the association or its members simply because he's not a financial member. Therefore, the fact that the second claimant is not a financial member of AMLSN is not an issue that affects the competence of this suit or prevents him from maintaining the suit against the defendants. Rather, since it was contended that the effect of not being a financial member is that he cannot hold a national responsibility in the association, it is therefore an issue that ought to be raised in defense of the claims of the second claimant, and not a valid ground upon which this court can be ought to decline jurisdiction to hear this suit. Having thoroughly considered all the issues raised in the two motions filed by the first and second defendants, the issues are resolved against the first and second defendants, except the issue of lack of approval to institute suit on behalf of the association, which is resolved in their favor. The prayer sought in the motion of 24th February 2025 is granted, while the motion of 4th March 2025 is dismissed. The third motion is the motion for contempt filed by the claimants. And I have expanded the content of the motion as well as the affidavits. In determining this motion, I have carefully examined the content of the processes filed by the parties. The claimants filed a motion ex parte, praying for orders of interim injunction, restraining the second defendant from parading himself as the national president of AMLSN and from interfering with the activities of AMLSN pending the determination of the motion on notice. In my ruling on the motion of 15th October, I ordered among other orders that the parties shall maintain status quo and will not disturb public peace forthwith. Now, in grounds 2 and 3 of the motion, the claimant stated that in the order made by this court on 15th October, the court ordered the second defendant to stop parading himself as the national president. But the second defendant did not obey the order and rather continued to parade himself as national president. It is on the basis of these grounds that the claimant has asked this court to commit the second defendant for contempt. My orders of 15th October are clear. Contrary to assertion of the claimant, no order was made on that day which restrained the second defendant from parading himself as national president. The court only ordered the parties to maintain status quo pending the hearing and determination of the motion on notice for interlocutory injunction, restraining the second defendant from parading himself as the national president. The court did not define the terms of the status quo, which the parties were ordered to maintain, and there was specific order in this ruling restraining the second. There was no specific order in the ruling restraining the second defendant from parading himself as the national president. Consequently, there is no specific and clear order in the ruling of that's 15th October, right? 15th October 2024, directed to the second defendant, upon which the claimant can ask this court to commit him for contempt. I find no merit in the motion and it is dismissed. The next one is the claimant's motion for interlocutory injunction, which was filed on 7th February 2025. And the orders sought are 4 in number, which I have reeled out. It was supported by an affidavit and written address. I've examined the content of these processes. Please give it to her. Can we read the judgment? The motion was supported with an affidavit. I have examined the content of this process. Tell her that when I finish, I'll come back. Should tell the way to.
Network will go down.
Okay. But I'll come back. Sorry, please, I have to. I've examined the content of these processes filed by the parties examining this motion. From the affidavit, he said after the judgment of this court delivered on 10th October, he was eventually sworn in as the national president of AMLSN on 25th June. But before then, the first defendant, who was restrained in the judgment from parading himself, constituted the National Electoral Committee, who conducted the election into the office of national president on 18th November 2023. The second defendant won the election for the office of national president, despite the fact that the claimant has been sworn in as national president in compliance with the judgment. The second defendant continued to parade himself as the national president of the association. In the counter affidavit of the first and second defendants, the second defendant claims that he is the validly elected and current national president of AMLSN. It was also averred that the 3-year tenure of office of national president, which was litigated in suit ABJ 368, has lapsed on 18/11/2023, on which date he was elected national president. I understand from the averments of the parties that the second claimant, as per the judgment of this court in suit ABJ 368, was sworn in as the national president on 24th June 2024. On the other hand, there was an election conducted on 18th November where the second defendant emerged 3 years. I have seen the claim sought by the claimant in this suit where he sought the court to determine the validity of the election of the second defendant as the national president. See release 4, 5, 6, and 8. He also wants the court to declare that he is the national president from the date of his swearing in. See reliefs 1, 2, 3, and 7. Thus, the main question that will arise for determination in this suit is who, between the claimant and the second defendant, is the right and valid current national president. This is the same issue the claimant has asked me to consider in this motion. And find that he is a valid national president. To find that he is a valid national president and then restrain the second defendant from parading himself as national president. It is the law that where an issue comes up in an interlocutory application and the same issue is likely to come up in the substantive suit, courts have been admonished that the correct action to be taken in such a situation is to refuse the application and hear the substantive suit. See Kwara Polytechnic versus Afolabi, 2010. Nigerian Civil Service Union versus ACN, 1985. Obidiegu Onyeso versus Nze Christopher Nnebedum, 1992. In other words, it is not proper to determine an issue which ought to be determined in the substantive suit during or in interlocutory applications. Any attempt to determine the motion will result to the court resolving a major issue which ought to be resolved in the substantive suit. It will not be proper to make an order restraining the second defendant before hearing the suit, which is meant to determine whether he is a legitimate person to occupy the position or not. For the foregoing reasons, I will refuse this application. In its stead, an order for accelerated hearing of the suit is hereby made.
The court pleases.
This suit will now be adjourned for trial. Future adjournments in this suit shall not be more than 1 week, and both sides shall call their witnesses on the same day. I shall also abridge the time for filing of final written addresses to 7 days for both sides and 3 days to file reply. Parties shall bear their respective costs. This is the ruling of the court, and it is entered accordingly.
As court pleases.
As the court pleases. My lord, we are most grateful for the sound resolution of the court in respect of all the applications. We are very happy. We thank you, my lord.
Thank you. So, are you in a position to take date now? I think we should immediately fix date for this accelerated trial of this suit.
My lord, there is a sister case that is coming up on the 17th and
of July.
17th of
is it June?
July.
Okay. Let me take a look.
A new case that was filed by my colleague.
Where is the red Ogbaga?
Yes.
No, this is blue. Where did I drop it? I used the other one. Maybe I sat on it. Maybe. So do we adjourn it to that date tentatively?
Yes, my lord.
Okay, bring the file. Let me enter it. So 17 July for I'll just adjourn it for hearing. When we get there, we'll now take a date or consecutive dates, maybe 3 days for hearing.
Yes, my lord.
And then
yes. Yes, my lord.
July 17th, 2026 for hearing.
Thank you, my lord.
Issue. So you issue hearing notice to the claimant, right?
Yes, my lord, to the second claimant. Yes, my lord.
He is the only claimant now.
Yes, my lord.
He is represented by counsel, so 2026. So the case is adjourned to 17 July 2026. Hearing notice to issue to the claimant. So, Mr. Barikwa, you get your ruling perhaps tomorrow, because today is already fast spent.
Yes, I will bring an application for the CTC of it tomorrow.
Okay. That's administrative, so they will deal with that at the registry. Thank you.
Thank you, my lord. I'm grateful, my lord. Thank you so much.
Thank you. Thank you.
Thank you.
Okay. What's the name of that?
Case number
4. Yes. Okay. Yes, call the next one.
Case number NSN/ABJ/309/2025 between Chinedu Chuks Ibe and the Director General of Department of GSS. Lord, party is absent.
309, right?
Yes, my lord.
My lord, my humble permission to take my leave.
Very well, Mr. Barikwa.
Thank you, my lord. I'm grateful, my lord.
Thank you. Thank you. Are the parties present?
Party is absent, my lord.
Appearances. They are not represented by counsel. Mohammed, appearances. Are they there? Are they here? Are they in court?
They are not. They are not, my lord. But we inform them, my lord.
Okay. So appearances name.
Yes, sir.
Are you in court?
Yes, sir. Respectfully, my lord, Magnus.
Magnus.
Ike. Magnus Nwangu.
Nwangu.
Yes, for the claimant, sir. For the plaintiff, sir.
Okay. Is there any representation for the defendants?
We inform the defendant. We informed the defendant that the matter is slated today for ruling. He said he was not aware, but I'm sure the registrar did inform the defendant.
Okay, no problem.
Thank you, sir.
Okay, so this is the ruling of the court. By notice of preliminary objection filed by the defendants on 21st January 2026, the defendant prayed the court to dismiss this suit for want of jurisdiction. The two grounds upon which the defendants premise their objection are: 1, the suit is statute barred as it has been overtaken by a statute of limitation, and 2, the claimant failed to exhaust the option available to him under the NSO regulations as adopted by the SSS before approaching the court, and this has robbed the court of its jurisdiction. When the PO was heard on 9th March 2026, learned counsel for the defendants applied to withdraw ground 1 of the PO and all the arguments made in regard to that ground in the written address in support of the PO. Learned counsel for the claimant did not oppose the application except to contend that the issue of the suit being statute barred should be dismissed because issues have been joined on it. At the time counsel for defendants applied to withdraw ground 1, he had not adopted his written address in support of the PO. Again, the claimant's counsel has not adopted his written address in opposition for the PO before the counsel for the defendant applied to withdraw ground 1 of the PO. Merely filing a response to an application does not amount to joining issues. Issues are joined when the court has heard parties on the application. In applications that are made in writing. Can you mute your mics, please? In applications that are pending. Mohammed.
Yes, my lord.
Can you mute your mic? You are disturbing me. In applications, merely filing a response to an application does not amount to joining issues. Issues are joined when the court has heard parties on the application. In applications that are made in writing, parties are heard when the processes are adopted. Thus, until parties have adopted their processes in respect of an application, issues cannot be said to have been joined. In my view, issues have not been joined in ground 1 of the PO when it was sought to be withdrawn. Accordingly, that ground cannot be subject to dismissal, having not been considered on its merits. The question of the defendants to withdraw ground 1 is granted. The application of the defendants to withdraw ground 1 of the PO is granted. The ground, together with the arguments made in that behalf in the written address in support of the PO, are struck out. The only ground of the PO to be the internal remedy before approaching the court. I have espoused the content of the written address filed in support of the PO. I've distilled the arguments there, both for and in opposition. I will skip reading those details, and there was also a reply. And then I will go straight to the decision on this plenary objection. The only ground of the defendant's objection is that the jurisdiction of this court has not been validly activated because the claimant failed to comply with a condition precedent to the commencement of this action, in that he failed to exhaust the internal administrative remedy before filing the suit. The allegation that a party failed to exhaust internal remedy is not an issue of law. Rather, it is a matter of fact to be established by evidence. Evidence is required to establish what the internal remedy is, what the procedure involved in such internal administrative remedy is, and how the party failed to comply or fulfill the administrative remedy. In this case, the defendants did not file an affidavit in support of the PO. They only filed a written address. In other words, the defendant did not support their contention with the required facts or evidence. There's no evidence adduced in this PO on what the internal administrative remedy is and how the claimant failed to exhaust him. In the defendant's reply on points of law, counsel referred to the provision of section 10(1) and 4 of the instrument number SSS1 of 1999 and section 7(1), 2, and 3 of the instrument number NSA2 to submit that the provisions contain the internal appeal procedure, which the claimant must exhaust before challenging his dismissal in court. The defendants did not file copies of the said instruments with their reply on points of law. They did not also produce copies of the instrument to the court. I recall I specifically ordered counsel for the defendants to avail the court copies of the instruments, but that was not done. As such, I have not seen the instruments and their content and contents to know whether they are applicable to the claimant's employment or not. The said instruments are not statutes or legislations. They do not fall among the documents which this court is mandated to take judicial notice of in section 122(2) of the Evidence Act. This court can only consider such instruments in deciding objections of this nature if they are produced before the court. In the absence of the instruments, the defendants failed to avail the court the necessary materials which the court needed to properly determine the ground of objection. Without the instruments being examined by the court, it is difficult to believe the defendants that there's an internal administrative remedy which the claimant failed to exhaust before filing this suit. The foregoing notwithstanding, I have considered the provisions of Section 10(1) and 4 of the instrument number SSS1 and Section 712 and 3 of instrument number NSA2 as set out by the defendant's counsel in paragraph 3.3 of the reply on points of law. What Section 10(1) and 4 of SSS1 provides is that appeal against the decision of the SSDC concerning senior staff of this on the service of grade level 08 and above shall lie with the National Security Agency's Appeal Committee. First of all, contrary to the arguments of learned counsel for the defendants, I have not seen any part of the provisions of Section 10(1) and 4 of the instrument number SSS1 and Section 712 and 3 of instrument number NSA2 set out by counsel, which require that an officer who is dissatisfied with the decision of the SSDC must first appeal to NSAAC before such an officer can institute a suit in the appropriate and competent court to challenge his dismissal from service. In my view, the provisions simply direct that an appeal against the decision of SSDC is to the NSAAC. That is to say, it is only an appeal against the decision of the SSDC that lies to the NSAAC and not the final ultimate decision of the employer or the service concerned. I do not therefore see anything in the provisions which prevents a dismissed officer from approaching the court to challenge his dismissal. Again, it is now settled law that once an officer is dismissed from service, he is no longer subject to the part of the condition of service which requires him to comply with the provisions with respect to the internal administrative remedy provided therein before he can approach the court. While still in service, before dismissal or termination, the officer is bound to comply with the conditions of service. But once he has exited the service, the conditions of service no longer applies to him. See Nwankwo versus Nigeria Army 2021. In this case, from the moment the claimant was dismissed from service, the claimant was no longer considered to be an officer in the service of the second defendant, and accordingly no longer subject to the instruments or regulations governing this service. If the claimant had not been dismissed before he instituted this suit, he would have been bound to comply fully with the requirements of the internal appeal process before his suit can be entertained. In the circumstance, the claimant is not under any obligation to comply with the internal appeal process before approaching the court. In any event, the claimant pleaded in paragraphs 24, 25, 26, 27, and 30 that he lodged several appeals against his dismissal, the first being on 10 September 2021. But nothing was done on his appeals to his knowledge until 26 September 2025, when he was told that his appeals were treated and dismissed. I have seen the letters dated 10 September 2021, 16 December 2024, and 10 June 2025, front-loaded by the claimant. These are letters of appeal against his dismissal addressed to the first defendant. By these letters, I find that the claimant filed an appeal against his dismissal. The claimant also pleaded that he was told that his appeal has been determined and dismissed before he filed this suit. In view of the facts pleaded by the claimant, he has shown that he had taken steps to appeal his dismissal, and he was informed of the determination of the appeal before he instituted this suit. In view of the facts pleaded by the claimant, he has disclosed that he lodged appeal against his dismissal, and he was informed of the outcome of the appeal before he instituted this suit. The result of the foregoing is that I do not find merit in the notice of preliminary objection. It is accordingly dismissed. The case will proceed to trial, and parties shall bear their respective costs. This is the ruling of the court, and it is entered accordingly.
As God pleases.
My lord, thank you very much for this erudite ruling. May God bless your lordship. We appreciate your lordship. Thank you very much, sir. God bless you.
We take a date for hearing.
Yes, sir.
Since the matter is going to proceed for hearing, I can give you a tentative date of before we enter into the new legal year. I can give you a tentative date for 17 July. Perhaps we'll just mention the matter and now take hearing dates.
17 July is convenient.
Okay.
Thank you very much, sir.
Thank you. The case is adjourned to 17 July 2026 for hearing. Hearing notice to
As court,
issue to
please.
the defense.
As court,
Thank
please.
you.
As court, please. Thank you, sir.
Thank you. So there's one more.
Yes, Lord. Case number NSN/ABJ/256/2023 between Mr. Teflos Anuwe and Federal Character Commission. Without parties absent.
256, right?
Yes, my lord.
Okay.
Call my matter.
My lord, the plaintiff is here. I'm waiting for him to announce appearance.
I'm coming. I'm just trying to do something. Please, just give me a second. Cancel. I don't want to get the files mixed up. What is this one? Okay. Two, 5, 6. Parties are absent, right? Mr.
Yes,
Mohammed.
Yes, my lord. No.
Appearances.
With profound respect to my noble lord.
Yes.
My name is Vincent Adodo.
Yes.
Most respectfully, I appeal for the plaintiff, who is also the applicant in this application. I'm grateful to your lordship.
Yes.
My lord, with utmost respect and humility.
Yes.
Obiabo Francis Amedu. Obiabo is OBI.
Yes. Yes. Mr. Amedu.
Yes, my lord. For the defendant.
You started spelling Obiabo. O-B-I.
Yes. A-B-O, sir.
A-B-O.
Yes,
Francis
Amedu.
Amedu.
Amedu is A-M-E-D-U.
Yes.
For the defendant, my lord. For the defendant, my lord.
Thank you. Okay. This is the ruling of the court.
As the court pleases.
The claimant instituted this suit by a complaint filed on 19 September 2023. He later amended the complaint and statement of facts on 18th October 2024. He filed a witness statement on oath together with the amended originating processes. The claimant opened his case and testified in chief on 7th March 2025. By adopting the witness statement, he deposed on 18th October 2024. At the time the claimant gave evidence, the defendant had not filed their statement of defense and were not represented by counsel on that day. After the evidence in chief of the claimant, the matter was adjourned for cross-examination of the claimant. On 28 April 2025, leave was granted to the defendants to file their statement of defense, and the statement of defense earlier filed on 14 April 2025 was accordingly deemed. The claimant filed a reply to the statement of defense on 25th April 2025, together with a further witness statement on oath. On 11 November 2025, the claimant was granted leave to further amend the complaint and the statement of facts. The further amended complaint and statement of facts was filed on 26 May 2025, together with a witness statement on oath of the claimant. In the proceedings of 21st January 2026, counsel for the claimant reminded the court that the claimant has recently amended the statement of facts, and he proceeded to call the claimant to continue his evidence. The claimant adopted his further witness statement on oath filed alongside the claimant's reply to the statement of defense, and he was cross-examined. The claimant closed his case on that day, and the matter was adjourned to 26 February 2026 for the defendants to open their defense. However, on 18 February 2026, the claimant brought a motion wherein he prayed for these orders: an order granting leave to the claimant to reopen his case, an order for the recall of the claimant to adopt his witness statement on oath in support of his further amended statement of facts, and for such further orders as this court may deem fit to make. It was supported by an affidavit and a written address. The defendants, in opposing the motion, filed the counter affidavit and written address on 24 February 2026. The counter affidavit was deposed to by Stella Ezekiel, a front desk officer. I have examined all these processes filed for and against the motion. From the grounds of the motion, the facts deposed in the affidavit in support, as well as the submissions made by counsel for the claimant in the written address, the reason given by the claimant for making the application for the reopening of his case and for his recall to give further evidence is that on 21st January 2026, when he adopted his further witness statement on oath and closed his case, he inadvertently omitted to adopt his witness statement on oath filed in support of the further amended statement of facts. Hence, this application to enable him adopt the said omitted witness statement on oath. The grant of an application to reopen a party's case after it has been closed and to recall a witness is at the discretion of the court. However, the discretion is not exercised by the court as a matter of course. The party seeking to call or recall a witness after the party's case has been closed is required to present cogent, credible, and convincing reasons to the court as to why his case should be reopened to enable him call or recall a witness. See Willoughby versus Merchant Bank Nigeria Limited, 1987, Musa versus Dalwa, 2010, Okonkwo versus Nwaosha, 2016. Now, in Omoregbe versus Lawani, 1980, the Supreme Court held that the judge has always a discretionary power with which the court above is very unwilling to interfere, of recalling witnesses at any stage of trial, and of putting questions to them as the exigency of justice requires. He will seldom, however, except in special circumstances, permit a plaintiff after his case is closed to recall a witness to prove a material fact, although the application will in general be entertained if made before the closing of the plaintiff's case. In the background facts to this application, I stated that the claimant had closed his case after adopting 2 witness statements and was cross-examined by counsel for the defendants. Now that the claimant wants to reopen his case and be recalled to give further evidence, the claimant must present good, substantial, and special reasons to the court why he should be accorded that opportunity. I've gone through the affidavit in support of the motion. The claimant has not given any good, substantial, and special reason to convince the court to grant his prayers. What he said is that he inadvertently omitted to adopt the witness statement of 26 May 2025. Again, in paragraph 3F and G of the affidavit in support of the motion, an attempt was made to put the fault on counsel for the claimant. It was stated that the omission was the fault of counsel, who was under the error that the witness statement adopted on 7/3 was sufficient, as there were no new documents to be tendered under the witness statement of 26 May 2025. The claimant's counsel, who filed this application on behalf of the claimant, thought that by simply putting the fault on himself will attract the sympathy of the court in favor of the claimant. I recall that counsel for the claimant informed the court during proceedings of 21st January that the claimant has recently amended his statement of facts before he proceeded to call the claimant to continue his evidence. Counsel was aware that there was a witness statement filed together with the amended statement of facts. He is also the one in control of prosecuting the claimant's case. In my view, the failure of counsel to lead the claimant to adopt the witness statement was a deliberate act. He knew what he was doing. I cannot therefore be swayed by fault of counsel, quote and unquote, excuse which counsel wants to rely on. The claimant has not given or shown any special reason in this application which will entitle him to reopen his case and be recalled to give further evidence. I have gone further to examine the evidence given by the claimant on 7th March and compared with the content of the written statement on oath filed on 26 May, which he wants to be recalled to adopt. I cannot find any material difference in them. What the claimant has already told the court and put in evidence is the same thing he wants to return to repeat. There's no prayer in this application seeking to have the evidence he gave on 7/3 expunged from the record. Therefore, I cannot exercise my discretion in favor of the claimant to allow this application for the claimant to merely repeat the evidence already on record. In view of the foregoing, the application fails and it is hereby dismissed. The case will proceed for defense to open. No order as to cause. Ruling is entered accordingly.
My
Lord,
I agree with your lordship for the well-considered ruling, my lord. Sir.
Thank you.
Thank you, my lord.
My lord, we must not fail to thank the court for the well-considered ruling and the clarity of your lordship's thoughts. We pray that God will continue to grant my lord good health to discharge justice to all parties.
Thank you very much. I understand that some of you have been very anxious about the delay in delivering the ruling. It's due to the lack of, the volume of work we are inundated with, and that's why we had to take so much time. And
my lord, we understand, and I'm sure the claimant understands too.
Yes, I believe we'll be able to move very quickly going forward. When do you want to come back? You want us to fix it
my lord, if your lordship can say
yes.
First, let me thank your lordship and appreciate your lordship's efforts and to state that we understand the workload of the court. My noble lord, if your lordship will be gracious enough, we will still ask for a date in this month, June. My noble lord, subject to my lord's convenience.
My lord, is for defense, my lord. It's not for it's our witness that will be called, and the person that we are calling is a retiree that has gone back to his village.
It's not more your case now. How can you determine?
My lord, we see that the court had already given July dates, and the 17th is convenient to us, my lord. 17th or 16th July.
To be honest with you, how many witnesses are you calling?
Just one, my lord. Just one. Just his sole witness. But he's a retiree. He has retired from the services of the defendant and is back to his village. So we have to notify him on time and then make logistics for him to come, provide logistics for him to come.
Okay, I think at this point we now rule off 17th of July. After now, we'll not all matters will have to go until after the vacation. Is Mr. Dodo, are you okay with 17 July?
My noble Lord is convenient.
Okay.
My Lord, we are grateful for the indulgence.
About the matter. Okay.
So that means we have 6 cases coming up on that day. Although the other 2 may not 2, 5, 6, 2023 defense, right? Yeah. The case is adjourned to 17th July 2026 for defense. So the case is adjourned to 17th July 2026 for defense.
As the court pleases.
No.
All right. That will be all. In the absence of any other, the court will rise. I'll leave the meeting room now. Thank you.
Thank you.